Hi, I'm going to speak about some of the issues that come up when you are entering into a software related licensing agreement with another company. Now, of course, there are many softwares which are paid and on a B2C basis, but there are several other softwares and apps which are used by businesses. So it's on a B2B basis. And many such softwares are customized to the needs of business. Some of the largest software companies are making a huge amount of revenue from such customized software. So what are the legal issues that come up when you actually deliver such kind of customized software? One of the legal issues or one of the contractual issues actually is, of course, defining the manner, the mechanism of customization, the timelines of customization, coming up with a costing for it, and of course providing for some adjustment mechanisms in case there is an excessive amount of iterations received, or if costs increase, or if there are delays, so providing for mechanisms that accommodate such kind of variations in the contract without going for disputes. Okay, but keeping that part aside, there are some legal issues that lawyers frequently end up negotiating. Out of these legal issues, I want to focus on three right now. One is confidentiality, the second is indemnity, and the third is limitation of liability. Okay, so if you've ever read the terms and conditions of any app that you've downloaded on your own personal computer, you will see that the warranty or the representation or the limitation of liability goes like this. The software term states that you are taking the software on an as-is basis, and there is no warranty of any suitability for any particular purpose, and that in case of malfunction of the software, there is no liability of the software provider. Shocking, isn't it? For most products, you usually get a warranty which you purchase, but for software, that's not the case. Now, this is most often the case for free software. In some paid softwares, however, uh, there are some amounts stated for damages or for malfunction that are provided. Now, let's see how this works. So let's park confidentiality for the time being, and let's look at the indemnity provision. Okay. Now, in most of these contracts, the indemnity is to the extent. Now, the principle of indemnity is that if something that I give you or some action that I take causes a loss to you, I need to indemnify you for the loss that you suffered. Right now, if my software makes you suffer a very high loss, then I could be liable for. If the malfunction of the software I've provided you makes you suffer a very high loss, then my liability could go very, very high. So I need to cap that amount, right? So in most cases, the indemnity is capped at a fraction of the software license fee payable. So if you're having an annual licensing contract, this could be capped at, let's say, 6 months license fee or the whole year's license fee. Now, how much that cap is a function of negotiation and can differ from contract to contract, but parties always want a cap to be there. Secondly, they will also state that, so this cap is the limitation of liability and the principle that you are responsible for indemnification in case there is a loss caused to the other side is under the indemnity clause. At the same time, there is an exclusion for any indirect or special kinds of losses or consequential losses which result as a second or third level of the malfunction of the software. So one will be a direct loss that you'll not be able to use the software and that will cause some loss, but that will lead to a trigger effect, a cascading effect on many other aspects of your business if you're relying on that software, and might lead to a higher amount of loss. Now, this amount is usually excluded by the indemnity clause. Okay. Now this is the principle that I've said, but every time you do a deal with the client, there is going to be a negotiation on this, and the clients may want to remove any cap on indemnity. They may say that, or they may impose unnecessarily high amounts of indemnity, or they may say that you're liable for indirect or special losses also because their business depends on your app, because it's a core part of the function of their business. Okay, so this can arise. The other aspect is about confidentiality. Now, each company is required to maintain enough systems to ensure that when you use the software, there is no leakage of confidential data. Okay. Now, most of your software is compiled software. Okay. So here, the prohibition that will be there is you will not decompile or try to reverse engineer the software. But there may be confidentiality aspects about the business model of the two parties that that gets exchanged at the time that the two companies are negotiating the deal, finalizing the deal, operationalizing and implementing the deal. Okay, at this time, what happens? Now, most parties do not agree to have any cap from this breach of confidentiality. So whatever is your limitation of liability amount, that is applicable to all situations other than a breach of confidentiality. In case of a breach of confidentiality, you may need to indemnify for any losses, or you may need to pay damages, okay, to the extent the damages are proven. But what is most commonly asked for is an injunction from disclosure. So a breach of confidentiality means that, the information is leaked out and it is further being leaked out. So a restriction on any disclosure ensures that the damage caused from that leak stops then and there. I hope you found this useful. I look forward to hearing from you as to what are the practical challenges you face while negotiating such agreements.